The Supreme Court expresses skepticism over Hawaii's vampire rule. Plus, the ATF proposes redefining who counts as an unlawful drug user. All this and more on the news update.
No, the devil's got no hold on me.
All right, ladies and gentlemen, welcome back to the news update. I'm contributing writer Jake Fogleman, joined as always by Reload founder Stephen Gutowski. TheReload.com, of course, is where you can head on over today to sign up for our free weekly newsletter. It'll keep you up to date on all things happening in the world of gun politics and policy. This week, of course, the big news was that the Supreme Court heard its first oral arguments in the very first Second Amendment case that we'll be hearing this session. That is Wolford versus Lopez, case concerning Hawaii's so-called vampire rule. And I have to say, this oral argument was a pretty fascinating one.
Pretty long one too, right?
Yeah.
They don't usually go. This is, I think, almost 2 hours, and usually they're like an hour. So probably because the Solicitor General's office decided to get involved in this case, as we've discussed before. They're not a party to the case, but they support the plaintiffs here challenging Hawaii's law, and so the U.S. government, the federal government, got its own slice of time to make its argument in support of the challenge. And so it was kind of a marathon oral argument, which I feel like maybe they've been doing that a little more often at the court lately, but I was not used to it. And it was quite the marathon hearing. And but a lot of interesting things were discussed. And I think you get a lot of insight into what the justices are thinking, right? And we're actually going to have Alan Beck on the show. He was the lawyer for Wolford, the challenger here. So he's going to be back on. We had him on before oral arguments a couple weeks back, and now we're going to have him on to go over how they went and what his thoughts are and how he's feeling about the case, and just go over some of the finer details of also that he was in the room. Like, we both listened to it live, and I went through the transcript afterwards, and so we have some good insight. But it's a different thing to actually be in the room and see the justices' expressions, and so I think he'll have a little more information to relay to us, and then we'll ask him about the finer details of his case. But, from what we have now, and, obviously Alan will be on this week, so he'll be Sunday for Reload members, and which it'll come out Monday for everybody else. But for now, I think we have a lot to go off of, and, I definitely think that it's that Alan's going to win this case. Just at the end of the day, just to skip ahead to all the spoilers, I think from oral arguments that all of the conservative justices, at least, will be on board with striking down this law. I think it's also, that's not necessarily surprising, because just structurally, that's what I would expect to happen, because you recall how this case got to the Supreme Court. That the Ninth Circuit upheld Hawaii's version of this so-called vampire rule, this default swap, where they, instead of the presumption being that anyone who's licensed to carry or legally allowed to carry can go on to public accessible private property like a store or a restaurant without express permission, unless the owner has indicated they're not allowed to bring guns on, usually by posting a sign that says no guns. Hawaii has swapped that around to say, unless the owner has posted a sign or given some other indication. That was actually key in this Ninth Circuit case, because California had a very similar law, but they required the owners to post a sign that said guns were allowed. Hawaii's law just requires some sort of consent from the owners. So I guess it could be verbal instead of a sign, but the same practical issue arises, which is that you need affirmative consent before you can enter the publicly accessible private property with your gun, which, to Alan's telling, made I think this was restricted to a specific island. I think it was Maui, but I'll have to ask him when he's on the show. But one of the islands, they did a survey, and essentially it made more than 95% of the public land off off limits to carry, like publicly accessible land. That included other sorts of restrictions that Hawaii already had, like park bans. But the bottom line is it made legal carry almost impossible. From that was the argument here. Now that was upheld by this Ninth Circuit panel. It struck down California's version, but it upheld Hawaii's, and it became the only circuit court to do that in the country. A number of other courts had gone the other way, and actually there's been an update to that count we'll talk about a little bit later in the show. But it created this circuit split. The Supreme Court took this case up, and that's the key bit I'm getting at here. A little bit long-winded, I apologize. But because the lower court upheld this law, and then the Supreme Court accepted that appeal, usually that means there's good reason to think the court is going to overturn what the lower court did. They don't usually take up appeals if they're just going to agree with the lower court. Now, maybe there's some, how broadly they overturn the lower court is, I think, the remaining question, and what the breakdown is, whether it's 6-3, 5-4, 7-2. That's the other big question. I'm leaning towards 6-3 at this point. I think all the conservatives in oral arguments were very skeptical of Hawaii's law, and especially of some of the ways they tried to justify the law, which we'll also get to. The black code that they cited from Louisiana in 1865. The justice had quite a lot to say about that, and none of it was good, I don't think. And so that's where I see things coming down. 6-3, probably. The liberals were more accepting of some of Hawaii's arguments, not necessarily the black code stuff, although we'll talk about that a little more in depth in a moment. But I think Hawaii tried to make this a case about property rights versus gun rights. They tried to establish that this is just about consent to enter somebody's property, and the government can create the default for that if they want to. And I think Sotomayor and Jackson were on board with that idea, and Kagan seemed to be at least sympathetic towards the historical analogs, even if she wasn't as interested in the property rights argument. A lot of that argument was saying this should be ended at Bruin step 1. It doesn't implicate the Second Amendment at all, because it's just a property rights issue. It's not a Second Amendment. It's not a gun rights issue. I don't know that Kagan was as interested in that, but she did seem sympathetic to the idea that some of the laws that Hawaii had cited for the step 2 analysis, the historical analysis, were or could be proper analogs, depending on what level of generality you're looking at it from. So I don't know. To me, it seems likely to be 6-3. I don't think any of the conservatives. The only one that seemed to have, there was a bit of, and we'll talk more in depth with Alan about this, but there's definitely a bit of at least confusion at the beginning between Barrett and Alan, I think, over not so much the question of publicly accessible private property, but more over residences and whether the right to carry would extend to carrying on somebody's non-publicly accessible private property. And so it seemed like maybe Barrett was a little bit, was pretty concerned about that question. But I don't know. I think in the end, she came around as well to being satisfied with his answer on that front, or with him and Harris, how they answered it. But so I don't know. And I just didn't see any other indication that the other conservatives had any thought of siding with Hawaii here. But I'm interested in what you think as well. So I'm thinking 6-3. What did you feel?
Yeah, my general takeaway is the same. I think it's probably minimum 6-3. We have another piece maybe we can get into in a little bit here, where an outside contributor posit the idea that, because Kagan was a little bit different in her approach than the other two liberals, that it could potentially be a 7-2. It's funny, when we, like you said, you and I both listened to the oral arguments, my immediate reaction after oral arguments ended was that thought at least entered my mind a little bit, just because it was sort of noteworthy how different Kagan's approach to probing this was. And she seemed to sort of, towards the end, when they were probing how this compares to other constitutional rights and how that interacts with private property, she seemed to be a little less comfortable with sort of like the limiting principle of allowing blanket, default blanket bans on private property, mostly in the First Amendment context, is how this came down. So that thought entered my mind. I don't know if that's going to be the case in the end, but I do think it's still 6-3 is the general baseline that we're probably going to be looking at here. And then the other thing I was struck by is in terms of the potential narrowness of the ruling, I did notice that they didn't really, obviously the court only took one of the two questions presented. And so that kind of limits, I think, how broad they're going to rule. But it just seemed like they didn't touch on any of the other sort of surrounding Second Amendment issues. It was like the arguments were only pertaining to this specific vampire rule law. And so I wouldn't be surprised to see yet another narrow Second Amendment ruling that doesn't really expand the boundaries of the court's Second Amendment jurisprudence. Obviously, oral arguments don't necessarily translate one-to-one to what the actual opinion is, but right. I wouldn't be shocked if it's just like, we think this is unconstitutional and that's about it. We're not going to actually tell you too much more about what the right means and how to do the Bruin test and yada, yada, yada.
Yeah, that's a good point, I think, because if you think back to Rahimi, the last Second Amendment case that the court did in 2023, was it 2023 or 2020? Mm-hmm. Yeah, it's been a couple of years. They've done other gun cases, as we've covered here, but they haven't done a lot of any Second Amendment cases until now, and this is the first of two that they've taken for this year. But they also are both the ones that have the potential to be pretty narrow. And as you mentioned, they didn't take up a broader question because there's a second question. The first question is just like, is this law constitutional, right? Right. Which, as you laid out there, is basically all they focused on in this case. Now, there was some discussion, like Kagan, on sort of generality, what the proper generality is, and how Rahimi really set generality. Because if you remember, Rahimi was 8-1, but the one dissent was Thomas, who wrote the Bruin test, in opinion, and his whole problem with it was that he thought they went way too generalized, and that was going to create a lot of issues. And so maybe they'll dive into that a little bit, because Kagan did allude to this idea that one of the disputes over Hawaii's historical analogs was that the founding laws that they put in to evidence were mainly focused on hunting on non-enclosed or enclosed properties. So basically, like, their anti-poaching laws is how even Kagan described them. But she was saying, well, it depends on sort of the level of generality you look at that from, as to whether or not they're similar to this Hawaii law. Even though the goal here is not to stop poaching, there's some similarities to it, depending on how much you zoom out. And so maybe they'll get into that a little bit. But one of the second question they were asked, at least, and decided not to answer, was the historical scope. Like, when do laws stop being relevant to this inquiry, right? Because the whole point of the history test is to try and understand the Second Amendment, the text of the Second Amendment, as it would have been understood when it was ratified. And the way the court has decided to go about doing that is by looking at historical gun laws and seeing, how did the people at the founding or near the founding, most relevantly, think they could regulate guns in light of the Second Amendment being, in place. And so there's they've talked about there being some trail off to the usefulness of laws, the further away you get from the Second Amendment, but the ratification of the Second Amendment. But they haven't actually set any sort of hard lines on that, and they decided not to, as you discussed there, even answer that question officially as part of this inquiry. So I don't know, maybe they could still do it anyway, right? Or they could put some data in there that talks about this. You could get a bunch of, there's been some discussion that it's not really a 6-3 court on the Second Amendment questions. It's more like a, 3-2-3 or 3-1-1-3, like there's that the split is much more diffuse than just an ideological split or a split along, party lines of who judges were appointed by. And so you could certainly see, like we saw in Bruin itself, a bunch of concurrences, or in Rahimi was a bunch of concurrences, and it'll be interesting to see exactly how they do. But you're right. I think they probably will just focus on this being an outlier law. They're pretty comfortable with doing that, right? We've talked about that in the past. Like,
right.
Heller was an outlaw. The handgun ban, by the time they heard it, was a significant outlier from how the rest of the country regulated handguns. Same for Bruin. New York's law was an outlier by that point. Only a handful of states had those kinds of laws. This is an outlier. Only 5 states have this sort of regulation, this vampire rule. And so I think it would be a pretty easy, just structurally, for them to just be like, yeah, this law is unconstitutional. There's not enough historical support for this sort of regulation. In fact, all of the history really points in the other direction here, and not really deal with any of the bigger questions about how to apply the Bruin test or whatever. So, but even if they go that direction, it'll be valuable and important ruling, just because, as we discussed before, like, they just don't have a lot of Second Amendment rulings. So anything they write is going to be very important to the lower courts. It doesn't, because there's only 5 of these cases. It's not like the First Amendment. You could look back and see hundreds of cases on it. Second Amendment, far less so. Although, one other theme that definitely came through from the conservative justices, at least, is that they still are very focused on this idea that the Second Amendment is treated as a second-class right. Roberts talked about this a lot in his comments, and that they don't think it should be treated that way, and that he literally just said at one point, I believe it was Roberts, might have been Gorsuch, that just said, aren't you doing that? You're treating this as a second-class right. You wouldn't do this. There was a whole long discussion about how, well, would this be constitutional if you did it in First Amendment context, or and I think that was pretty instructive as well. That they don't seem to have changed their mind, and they still are very much emphasizing the idea that they don't think the Second Amendment is getting the kind of respect, I guess, from states that they think it should. So, but to that point, you and I think 6'3". We had an outside contributor this week, Rob Dorr. He's a gun litigator out in Minnesota. He works with the Minnesota Gun Owners Caucus, and he runs their law center. And he had, I thought, an interesting take that, as we alluded to already here, that Kagan might actually go. This might be 7-2 instead of 6-3. And do you just want to give a little rundown as to why he thinks that?
Yeah. So one of the things he emphasized was sort of what we talked about at the top of this, is her separation from her 2 liberal colleagues. Is like you said, they very much were all on board with the idea that actually this doesn't even touch the Second Amendment to begin with. So this is an easy case to resolve the other way. You don't have a Second Amendment right to carry on someone else's property. Therefore, we don't even have to do the Bruin test, and this could just be decided off the bat. She didn't really seem to buy that one bit, and she was much more interested in trying to do the Bruin test and get into discussions of the level of generality. She also seemed to be less entertaining of another thing that we're probably going to get into, because you wrote an analysis piece about it, like the black codes discussion, whereas Justice Jackson, I don't want to say she necessarily endorsed the black codes, but she was saying that you almost have to include that in the Bruin test. And I think she was more so trying to make a broader point about how much she doesn't like the Bruin test, quite frankly. We'll get into that for sure. And so, she took the Bruin analysis a little more seriously, and she was a little more uncomfortable, I would say, in those First Amendment comparisons that we were just talking about. Like, I think she posed a hypothetical about, could you set a default? Could the government set a default that people cannot distribute leaflets at a shopping mall or something like that, some sort of publicly accessible private property? And it was, again, like you said, sort of telling interactions with Hawaii's lawyer, because he started talking about, well, there's all sorts of viewpoint discrimination case law in from the Supreme Court on the First Amendment, and so I think that probably would violate the First Amendment. And so,
Yeah, it was kind of
a
funny.
lot
They
of these,
kept giving him these examples of like, well, if you did things this, and then a lot of it was around like pamphleting or campaigning. Like, could you go to someone's door if you were campaigned? And Neil Cattell is the lawyer for Hawaii in this case. He's a prominent lawyer, does a lot of major litigation like this. But yeah, he kind of kept saying, no, it would be unconstitutional in these other circumstances that the judges were putting up, including Kagan, who to your point and to Rob's point here, said, quote, suppose a state said you cannot leaflet in shopping centers unless you secure permission first. That was her hypothetical, which, I think just the construction of it, as Rob points out, implies that she's very skeptical of this concept and how it could be cross-applied across the different rights secured by the Bill of Rights. And again, it's one of her, I'll just quote from Rob's piece a little bit here. He said at one point to illustrate what you were saying here, Rob says, quote, Justice Jackson went further still, framing the case almost entirely as a matter of property law, one in which once consent is required, the Second Amendment effectively drops out. Kagan resisted that move. She warned that, quote, to incorporate the burden into one's understanding of the scope of the right is a kind of category mistake, rejecting the effort to collapse Bruin at step one by redefining the right itself. And I think that actually is a fair reading of Kagan, because I went back, after he brought this up, I went back and read all of Kagan's questions, right, and her exchanges. Because again, this is like a 2-hour sort of marathon hearing. And I will say that a lot, unlike, as Rob was illustrating there, unlike Jackson and Sotomayor, who were much more willing to entertain the idea that this is more of a property rights case than a gun rights case, Kagan was focused on the specific historical analogs that Hawaii picked to defend their law and whether or not they could justify the regulation. She was much more focused on that step two analysis. Like Hawaii's best, I think their strongest argument, and the one that got the most purchase with the liberal justices, with Jackson and Sotomayor, was this idea that this isn't even really, the Second Amendment isn't implicated. We don't even need to go to step two of the Bruin test. We don't need to do the history analysis because the plain text of the Second Amendment is not implicated here because this is a property rights issue. Kagan did not seem to buy that and focused a lot of her time on the historical analysis. Now, the reason that I think you and I are not as confident that she's going to flip to vote against Hawaii's law is that when she was focusing on those laws, her points were, her questions were around the idea that perhaps these are good analogs, these anti-poaching laws. I'll give you a quote from her. She's talking to Alan Beck in this. She's asking him, about Hawaii's historical analogs, and she says, quote, in Rahimi, we said, you can go up a level of generality. You don't have to have a historical twin. There can be differences. In Rahimi, the essential similarity that we thought controlled was just that the guns were being used to protect against people who would be violent with their guns. Now, I think she misspoke a bit here. I think she's saying the restraining order in Rahimi, the gun ban question, was being used to protect against people who would be violent with their guns. And, that's a pretty general principle. And here the general principle is sort of similar. We think that there's a danger of various injuries occurring when you go onto private property with a gun. It might have been in the old days poaching. It might be something else now. So she's kind of giving this line about maybe these, she seems to think that it should go to step two, but she also indicated that maybe she thinks it survives the Bruin test, the history test. So that's I guess the lingering question is, does she think these laws are analogous enough to survive, or is she not convinced by that? And that'll determine, I think, where she comes down. But I thought Rob had a really good analysis of the situation, and he makes a he makes, some people think, well, maybe obviously look at the politics of the court and they think, well, Kagan might go over just because she wants a narrower ruling, right? She wants to have some influence over what the majority is going to say. And that's harder to suss out. We don't know how these things happen behind closed doors because they're behind closed doors, and they don't do that sort of horse trading out in public insofar as it occurs at all. But Rob has a different view where he says, Kagan has actually set up a different judicial viewpoint from the liberals in some instances, the other liberals. And so this joining the majority or voting against Hawaii in this case she might do that because she actually it fits better with her judicial philosophy. And I think that's another valid view to have here. And it's one that he lays out really competently. I think people should read his full piece over at the Reload.
Yeah, absolutely. But speaking of those differences in judicial philosophy, what we kind of alluded to, one of the other big sort of dividing lines in this oral argument had to do with a particular bit of odious history that Hawaii pretty heavily relied on, much I think you're surprised even before oral arguments, the fact that this was even invoked so heavily in some of their briefs. And that is, of course, the Black Codes, as you pointed out, an 1865 Louisiana law it's, to be frank, fairly similar to the modern vampire rule, but was passed sort of with the express purpose of disarming freedmen, newly freed slaves during a particularly racist part of this country's history. And it went over essentially like a lead balloon with most of the conservative justices, the fact that this was relied upon. But it also opened up some divisions with folks like Justice Jackson, for instance.
Yeah, I mean, I don't think it went over very well with the liberal justices either. I mean, Kagan and Sotomayor didn't talk about this at all. So it didn't seem like they were going to hang their hat on this concept that this one Louisiana law from 1865 from the Confederate Louisiana, which was part of the broader Black Codes, which are racist laws that were created with the express intention of restricting the rights of Black people in the post-Civil War South. But we talked about this before because when this showed up in Hawaii's brief, I was really surprised, honestly. I mean, this and obviously a lot of the Hawaii's brief, I think, focused on what we discussed earlier, this property rights argument that this really, you shouldn't even be doing the Bruin test, or it shouldn't get past this first step of the Bruin test. I still find it ironic that the Bruin test has 2 steps because Bruin's whole thing was that they didn't like the previous 2-step test and that it was just 1 step to the new test. But the justices all seem to have accepted that there's 2 steps here. But anyway, Hawaii's their main argument, their strongest argument, and what they spent a lot of the time on was this idea that this is a property rights issue and not a gun rights issue. But they, as their historical analog section for the step 2 analysis, they included this Black Code and a bunch of American Hawaii, like laws from the Kingdom of Hawaii that are defunct as part of their evidence. And I just thought that was extremely risky move, especially the Black Code part. And yeah, it turned out to have been, and it turned out to have gone over very poorly. Just to give you an idea here, here are the first 2 quotes that I put in our piece. It's a member's piece, but we'll give you some insight here. I want to understand how you think Black Code should inform this court's decision-making, Neil Gorsuch asked Hawaii's lead counsel, Neil Cattell, at one point. It's quite astonishing. It's quite an astonishing claim to me. And then that was followed up with Justice Samuel Alito saying, quote, is it not the height of irony to cite a law that was enacted for exactly the purpose of preventing someone from exercising the Second Amendment right, to cite this as an example of what the Second Amendment protects? So, that's kind of the reception that they got. A very cold reception from the conservative justices. And I don't even think I'd imagine that's probably going to play pretty bad against it. I wonder if you're going to get a pretty decent chunk of this opinion talking about how the black codes aren't good law. He was actually there was an even more sort of wild exchange, in my view, between Alito and Cattell at one point where, Alito is talking about this and he says, Mr. Cattell, wasn't the purpose of the laws in the post Reconstruction South that disarmed black people precisely to prevent them from doing what the Second Amendment is designed to protect, which is to defend yourself against attacks? They wanted to disarm the black population in order to help the Klan terrorize them, and law enforcement officers in that period in that region, they wanted to put them at the mercy of racist law enforcement officers. And Cattell responds, he says, so Justice Alito, we quite agree with you that parts of the black codes were motivated by and have that exact operation. And this is where it gets a bit wild to me. But he says, our point to you is this consent requirement did not operate that way. Indeed, if anything, it protected black churches and black-owned businesses and the like by insisting on this consent rule. And that is why the Radical Reconstruction Congress admitted Louisiana back in. They said no to various laws, but they never did that with respect to this. And this law stayed on the books for a long time. So he actually is arguing. Now, this was part of Hawaii's argument from the beginning. They were saying, yes, the black codes are racist, but this particular section of them was not. And that they had arguments around other similar policies from like Union generals at the time. And so they have argued before that this law that was passed as part of the black codes was not racist like the other sections were. This is the first time I've heard them say that it was actually protecting black people. That's a bit of a wild claim. I'd never heard anyone try to say that of any of the black codes before. But that's what he said in oral arguments. Now, I don't think this actually was persuasive to the justice because
Yeah.
the first response here came from Justice Kavanaugh. Brett Kavanaugh responding, he said, quote, well, on Louisiana in Ramos, on the jury trial right, the question of whether he had a right to unanimous jury, there were Louisiana and Oregon precedents going way back that allowed non-unanimous juries, and we flatly rejected that historical example for the exact reason that Justice Alito and Justice Gorsuch have been mentioning. Those were rooted in racial prejudice designed to prevent black juries from having their votes counted on juries in the wake of a decision like Straughter of 1880. And we just said, no, that's inadmissible to account for that as somehow justifying an exception to the constitutional right. It seems like the same kind of thing here. And Gorsuch, additionally, he said he rejected the idea that this law wasn't racist. He said it was adopted, quote, immediately after the Civil War as part of an effort, it appears, to disarm black people. And, quote, a Reconstruction governor later explained that this law, of course, was aimed at the freemen. So, and then the other thing that and actually Gorsuch got pretty upset at Keitel later on because the plaintiff's argument with this black code was essentially that it was an outlier, that it was unconstitutional, that and that it was racist, and so it shouldn't be accepted. Keitel didn't agree with that. But Gorsuch got frustrated at one point. He said, you're not answering the question. The question is it an outlier? And you just called it a shameful outlier. And I agree with that. And Brewin was supposed to look at the mainstream of our tradition and history, not outlying statutes that were unconstitutional the moment they were passed. And yes, when Louisiana was admitted to the Union. So Gorsuch certainly didn't buy the idea that this law wasn't racist or that its readmittance mattered. And then he had a particularly sharp jab here. He said, quote, I understand a lot of people like to cite the black codes who promote gun restrictions, who would otherwise they would be garlic in front of a vampire. But here they like them, they embrace them, and I'm really interested in why. And then Thomas himself, just to sum up the conservatives and their pretty intense reaction to this decision by Hawaii to cite this law. Thomas also argued essentially that, why should we consider these black codes in light of the 14th Amendment, right? So he says, if you're going to cite the Louisiana black codes of 1865, don't you also have to cite the subsequent adoption of the 14th Amendment that was in part generated because of laws like that? And Keitel argued that, he went back to this idea that the law survived readmission to the Union and that people didn't object to it at the time. And Thomas contested that. He said, quote, actually, there was quite, as I said in my McDonald opinion, quite a bit of discussion of these sorts of laws and the consideration of some that they thought that the privilege or immunities clause in the 14th Amendment preempted these. So, the conservatives, they went real hard after Hawaii's use of this racist law. Now, as you alluded to right earlier, Jackson took a little bit of a different approach. The liberals mostly ignored this, to be frank. Like the Sotomayor and Kagan didn't engage with this at all, but Jackson did pretty thoroughly. And I thought this is interesting, right? How she goes about this, because I think you summed up earlier. I don't know that she's actually saying this law is a good analog or that it should be used to justify Hawaii's modern law. I think this is much more about her distaste for the Bruin history test to begin with. And I think this seems to be her way of saying this history test is bad, right? So here's what she says, quote, and she's talking to Alan Beck about this situation, the plaintiff's lawyer. And she says, I guess I'm wondering whether that doesn't signal a problem with the Bruin test, that to the extent that we have a test that relies or relates to historical regulation, but all the history of regulation is not taken into account, I think there might be something wrong with that, with the test. I understand why you're saying they can't be used, but it's because we've moved away from that history, not because that history didn't exist. And so to the extent that the test today is tying us to historical circumstances, it would seem to me that all of history should be on the table. And if we start taking pieces off, whether it's because we've moved away from it or we don't agree with it anymore, I think there's going to be a problem with respect to the accuracy of our test. So I think that was the closest you got to somebody actually saying that this law should be considered good history for the Bruin test. And given Jackson's view of the Bruin test, and as she explicitly says there, I think it's much more her way of saying, look, what kind of any test where we have to consider these racist laws is a bad test. And you can't fix it by just ignoring the racist laws. Now, obviously, the response to that was along the lines of what Gorsuch said, and the plaintiffs made this argument as well, that this law was an outlier, that it was unconstitutional the entire time it was in place, and that's why it's not good history, not just that it was racist, but being racist made it those things as well. So anyway, that's kind of how that all went, which is to say really bad for Hawaii.
Right. Yeah. But to your point, I wouldn't be surprised to see a Justice Jackson dissent making this case, in her broader project of taking, barbs at the Bruin test and the fact that this is the way that the Second Amendment jurisprudence has gone. I would not be shocked to see that articulated in an ultimate dissent on this Hawaii law.
Yeah, and it's very much in line with how Jackson has approached all of these Second Amendment cases she's been a part of, which I make it sound like there's been a ton of them, but
yeah, right.
Only been a few, obviously, but every time her point is basically, I don't like this test. I don't think we should do this test. This test is bad, and so that's she does double down later on and keep talking about, well, why isn't this good history? Just because we think it's unconstitutional now doesn't mean it didn't exist, but I think my understanding of what she's arguing there is the idea that not that these racist laws were good. I mean, Hawaii doesn't argue that the racist laws were good either, although they do dispute that this particular part of the Black Code was racist, which is an interesting approach. I don't know how you could make that argument, frankly, but it's hard to rely on these sorts of laws for the obvious reasons that they're just abominable, right? Anyway, I still think her main point was, oh, I don't like the test, and look at what this test makes us do if we're applying it the way we're supposed to. It makes us consider these bad old laws. And that's in line with how she's argued about the Brown test since she's been on the court.
Yeah, no, that's right. But I think at the end of the day, both you and I expect her to, be on the losing end of that argument, and probably Hawaii's law will be struck down. And, the fact that when that oral argument was happening, we got some evidence from another part of the country that, it doesn't control what the Supreme Court does, but at least provides, I think, a little more support for that being the direction things are going to go. Because as the Supreme Court justices were weighing whether Hawaii's so-called vampire rule can be allowed to stand, a Fourth Circuit Court of Appeals panel was at the very same moment striking down the state of Maryland's also pretty much the exact same law that it passed in the wake of Bruin in a decision that was kind of weirdly split on some of the other Bruin response, sensitive places, gun-free zones restrictions. Unanimously, all three of the judges on the panel said, well, of course, this private property default swap is unconstitutional, and they struck it down. So,
yeah, let me give you a key quote here from that ruling. This is Judge Roger Gregory in Kipke v. Moore, and he said, quote, for the majority, he says, quote, Maryland's rule would effectively declare most public places gun-free zones, but that likely stretches the sensitive places doctrine too far. In short, there is no relevant historical tradition supporting Maryland's private property consent rule, at least on this record, and as to property held open to the public. And as we alluded to earlier, this has been the theme outside of this one Ninth Circuit decision. Every other court that's looked at this has struck down the vampire rule, and they've often done it the way that Maryland did here, or the way the Fourth Circuit did here with Maryland's law, which is to say that the vampire rule is too much, but every other sensitive places restriction is okay, basically. Yeah. As long as you can articulate a specific, definable area, that the courts, most of these more liberal-leaning circuits, have been happy to uphold those sensitive places restrictions. Once you get to something like the vampire rule, which is much, much broader than that, they've been much less. They've been much more reluctant to go along with the idea that that's constitutional. And so, like you said, another reason to think that the Supreme Court is very likely to strike down Hawaii's law. Yeah,
absolutely. Moving outside of the courts, though, we also had interesting news from the ATF. They submitted a interim final rule regarding how the agency defines what an unlawful user of drugs are for the purposes of Section 922G3, which obviously makes it disarms people who are habitual or unlawful users of controlled substances from purchasing or possessing firearms. And they introduced some new language in how they're interpreting what an unlawful drug user is to, in their telling, align with how courts are viewing that question these days.
Yeah, here's a quote from the proposal that ATF has published this week. They said, quote, not only have court decisions over the past 25 years consistently interpreted the statute to not include single-use inferences and to rest on regular use or a pattern of use, but ATF has also been interpreting the statute that way for most single-use denials for more than a decade and has changed its referral practices accordingly. Referral, by the way, is delayed denials. Sometimes delayed denials go through, like if you get delayed and it lasts more than 3 days before the FBI gets back to you and on your determination of whether you're allowed to, purchase a gun, the store is legally allowed to sell you the gun. And then sometimes, but the FBI doesn't stop the investigation at that point. They will continue to go until they make a determination if they can. And sometimes they will find out that you are, in fact, a prohibited person, and your status will be changed to denied, and they'll refer that to the ATF to go and retrieve the firearm from you. And so what they're saying there is the ATF's retrieval process, if they get a denial that's based on essentially a single drug use indicator, like a conviction or a charge or something like that, they don't actually go out and pick up those guns, is basically what they're saying. But to finish the quote here, it says that, quote, "This rule informs the public about ATF's current view of how the statutory term unlawful user of or addicted to a controlled substance should be construed, and clarifies how the department intends to enforce it in the context of firearms denials." So mostly when it comes to NICS checks, like you go and buy a gun from a store and you do the background check. The ATF wants to change how or whether you get denied around this particular disqualifier, the drug user disqualifier.
Yeah. So essentially just adjusting sort of the timeliness, like, the duration of your drug use, how long ago it was, and that sort of a thing, to move it, I think, more directionally in line with what's at least some gun rights advocates have been pushing for. Sure. This, of course, all comes in the context of the Supreme Court going to hear a case on this very question very shortly here, the U.S. v. Hermani case concerning 922G3 and someone who was an admitted marijuana user at the time that he was arrested, although there were other things, other circumstances that may come to play a role in that case as well. So a lot in flux here, and the ATF is reacting accordingly, it looks like.
Yeah, it's an interesting change, right? Obviously, they can't change the law
right.
And what the law says. They're just changing their interpretation of the law, and they're going with what I think is fairly closer to what courts have been saying for a while. That just somebody just having a single indicator that they use drugs is not enough, generally speaking. The ATF is moving more towards somebody who is an actual, who's addicted to the substance or is a user who's continually using, and it has to be around the period of when the purchase is happening as well, is another key bit to this new definition. Now, this I think the ATF does kind of make this point that this is kind of how they've been operating anyway. Is sort of what they're saying here, that it's only now they do give some numbers. I will say that it's about, I think, somewhere around 4,364 people were unable to receive or retain a firearm based on single-use inferences over, I think, the last year that they looked at. So that's about the number of people that they expect to be impacted. But that over a 10-year period, that gets into the tens of thousands. So that's not to say it's totally insignificant, but I think they deny tens of thousands of people per year. So it's not a huge percentage of the people who are getting denied, but it has some impact. Now, it doesn't necessarily, I don't know that it's the reform that gun rights advocates are pushing for. A lot of people want, for instance, recreational use of marijuana to be taken off the things that make you a prohibited user. This doesn't do that. If you use marijuana regularly, you would still be prohibited under this, because marijuana is still a Schedule III controlled substance. Now that's another thing that the Trump administration is looking at potentially changing. It hasn't changed yet, but for now, even if this change goes through, it doesn't make people who smoke weed regularly outside of that prohibition. Now, and it also does a kind of an odd thing where if you're a regular user of marijuana, you would still be considered prohibited under this. But if you've used heroin once, you wouldn't necessarily, right?
Right.
So this is all about the regularity of which you use drugs, not about the sort of seriousness of the drug, I guess, as the public perception might have it, but just more about the regularity, and also like evidence that you've done this. That's one of the things they're reforming, is like what shows as evidence that you are a drug user, and so that can be a series of charges against you or convictions. It can be a number of things, but they're sort of reducing how many things they'll consider as evidence of you being a drug user in context of this gun ban. So it is a change, and it's likely to have some significant effect, but also it kind of is one that at least the ATF is claiming that they've been practicing this way for nearly a decade. And so I don't expect it to be a massive sea change, and it doesn't solve the problem that gun rights advocates are primarily concerned with, which is this, at least some gun, not everybody agrees on this, but right. There's a substantial number of gun rights advocates who want the marijuana prohibition to be removed. This doesn't do that. But it does make changes that are noticeable.
That's right. Getting into some newsletter links that we had quickly, but ultimately stay on the same topic, frankly. The Washington Post had an interesting story this week that, we just talked about this coming as an ATF rule. The Post reports that the Department of Justice under the Trump administration has plans to make a concerted effort to do more of these kinds of things in the coming year, to do more gun regulation rollbacks, sort of this kind of stuff that, frankly, we talked about the Trump administration promising to do pretty early in his term, and maybe hasn't moved with the pace that a lot of gun rights advocates would have liked. And according to this reporting anyway, that's gotten through to some officials at the DOJ, and they have hinted at some plans to do more going forward this year.
Yeah, and I think we're seeing a little bit of that already in practice, including this ATF proposed rule change, and then also that Office of Legal Counsel opinion that we talked about last week when it comes to shipping guns through the Postal Service. That these are signs that there is some movement here. Now the OLC opinion is not binding necessarily, so we'll have to see what happens with USPS and whether they follow through on that and whatnot. But and there's also some reason to be a little skeptical about this Post report because if you've been following along for long enough, you will know that was something and the Post report admits this. It was something that they had already said was going to happen. I think back during the Doge days, there was a claim that some Doge team had showed up to ATF and they were going to do 47 rule changes, which I think we were very skeptical about at the time. And then, none of those seem to have come to fruition. There's a number of things where the Trump on the campaign trail had promised to undo everything Biden had done in the first week. And he definitely didn't do that. Now, look, if he eventually does all these changes that gun rights advocates want, they may not hold it against him on the time scale here. But there's reason to be skeptical, perhaps, that this is going to pan out. Because the last time the Post reported this, it didn't pan out. And also in this one has no clear time scale to it. They in fact, they talk about not wanting to do this stuff before Robert Cicada is actually confirmed as ATF director, which is not supposed to happen until next month. His hearing is not supposed to happen until next month. And who knows if he gets converted. We'll just have to see how that all goes, obviously. But they were talking about in the Post piece not wanting to, complicate that effort because it's hard to get an ATF director confirmed. Which, I don't know why you go out and leak this sort of story before it comes up, if that's your concern. But either way, the implication is they're not going to do any of this stuff for maybe a couple months at least. We only know what they are going to. But I don't have any extra insight here into what's going on internally at the ATF right now. But yeah, certainly something we're going to watch. And then I think there was we also had a CNN piece, right, that delved into the ATF and what's going on.
That's right. Yeah, CNN basically confirms what I think you and I were already operating on the assumption was the case anyway, and that is that the trial balloon that was floated by the Trump administration that proposed merging the ATF with the Drug Enforcement Administration, that's essentially dead. That's essentially not going to happen. It's off the table. You and I talked about sort of the backlash that immediately garnered from gun rights advocates as soon as it was proposed, and sort of assumed that wasn't not going to happen because of that. And we didn't see obviously in all the appropriations bills that have been circulating through Congress, there was no plans. It wasn't baked into any of those. And so now CNN's reporting that is in fact the case, that the administration officials have moved on from that idea.
Yeah, I mean, I just think it got zero purchase with Republicans in Congress, which is, a bit remarkable given how this Congress has acted toward this president, right? They've been very, obviously, it's not uncommon for a Congress controlled by the president's party to do a lot of what he wants, but I'd say it's even more so of late with Trump, the way Trump leads the Republican Party is with a much tighter grip than a lot of other presidents have had to this point, even more so than in his first term, but not totally though, as we see here. And the idea of merging ATF into we thought maybe that would happen with the FBI after Kash Patel became the acting director of the FBI, but that went nowhere, and it's not even clear how long Patel was the director. He doesn't. I think there was a report that it could have been as short as a day. But either way, right. There was some thought maybe that was a way of sort of informally merging the two agencies, and then there was open talk about merging them with the DEA, which gun rights advocates did not like at all. I'm sure the administration seemed to think of this as kind of a way to shrink and streamline ATF and DEA together, and that might be a way of diminishing the power of the ATF. But I think a lot of the gun rights advocates were worried that would do the exact opposite, and it would eliminate some of the specialization that the ATF has, that the industry relies on. So they didn't like that either. And there's just kind of a devil you know versus devil you don't, I think, attitude among gun rights advocates towards this kind of plan. Now, a lot of them, you'll see a lot of gun rights advocates just want the total elimination of the ATF. We've discussed that before with the current chief counsel, Robert Leiter. The ATF has been on the show to talk about that before he was chief counsel. But yeah, ultimately, there just never was any momentum for this idea among gun rights advocates or in Congress among Republicans. You saw Republicans publicly speaking out against the concept. And as you mentioned, never made it into any of the appropriations despite what the White House requested. So, that idea is, I think, long gone at this point. And that's, I think, all we got as far as news goes. I always spent a lot of time on that Supreme Court ruling because, as I emphasized earlier, every single Second Amendment case means a lot, even if they do go narrow on the decision. And it is something that only 5 states have, like this vampire rule law. But just because of how few of these cases they've done, we're at the baby steps, the foundations of their Second Amendment jurisprudence. So every case matters a lot. And so that's why we spent quite a bit of time on it. And that's why we're also going to have Alan Beck on the interview podcast to discuss oral arguments further this week. But that's all we've got as far as news. You got any fun plans this weekend? I don't know if there's a whole nationwide blizzard ice storm coming. I don't know how much Colorado is impacted, or you guys are kind of used to that kind of weather.
I see. Not a ton of snow, but it's going to be pretty frigid this weekend. And so I think I'll be staying inside mostly, which is fine. And I'll be nervously watching my Broncos in the AFC Championship with a backup quarterback. So Philly fan, if you could send me some,
I feel so bad.
Send me some Nick Foles. Send me some Nick Foles vibes.
Maybe was it Stidham?
Yeah, Jarrett Stidham.
Maybe he's the next Foles. New England does not do well again. Foles had a tweet about this, actually.
Yeah, I know. I love it. It's my favorite tweet I've seen, I think, in months.
And plus, I think Broncos, your strength wasn't Bo Nix. Not that he's a good quarterback, but your strength is your defense anyway.
That's right.
You still have a good chance, I think, of toughing it out. And so it'll be interesting to see how that all plays out. But that is brutal that he got hurt on the second to last play.
Yep.
In a way that wasn't even noticeable watching. That is rough. But I still believe you guys could. Yeah, I just don't think the Patriots are that much of a juggernaut anyway. So you still got a really good chance of getting it out. So good luck on that.
Thanks.
I will probably be stuck in my apartment all weekend, I assume. I'm in Virginia here, and there's probably going to be a foot of snow is what they're saying, which is not a common thing to happen here. It does happen every, I don't know, decade or so. but I'd rather that than the ice that people further south are going to get. I think that's going to be a huge disaster. So if you are in the south, please prepare yourself for losing power and not being able to travel for a while. That is a realistic possibility. Keep yourself safe. Sadly, my Jeep, I won't even have my Jeep for this storm. I have one of those 4xe, the hybrid, plug-in hybrids that they've had so many problems with. And it passed the recall for the battery, but then a couple weeks later, the check engine light comes on, and now it's stuck at the shop because they had some issue in them trying to read what exactly the check engine light needs. But I kind of suspect the battery is bad and needs to be replaced. The big hybrid battery is bad because that's been the main problem with these things. And that usually takes like a month to get. Now, it doesn't cost me anything because it's all under warranty, but I won't have my Jeep for this massive snowstorm, which sucks. Hopefully I can get them to, they're offering me the dealership only has certain kind of cars, right? Dodge Hornets, the ones that they can't sell is what they have as loaners, right? That is pretty different from a Jeep Wrangler, as anyone who knows those two cars would know. But hopefully I can get them to Jeep, the big company, not the dealership, to give me a Wrangler. We'll see. I kind of doubt it. I think I might be stuck inside all weekend. We'll see. So wish me luck on that. I should go up to the mountain and spend it stuck there, but I don't think I'm going to have the opportunity to do that, unfortunately. Anyway, we will continue to bring you Reload coverage even in the middle of a nationwide blizzard. So if you're not a Reload member yet, go and sign up, and you'll have a good piece to read this weekend and a nice interview with Alan Beck, the lawyer from Wolford v. Lopez. So look forward to that. And we will see you guys again real soon.